must say, we do find, how shall we say, a slight deficit in rationality in some of the criticism that's been levelled
but let's pick up something.
Opening up of this debate.
But let's pick up something from yesterday. Justice Minister Jeff Radebe said, and I quote from the document, he said, "The President's comments relating to the review of the powers of the Constitutional Court is consonant with the rationalization project mandated by the Constitution." And the question is he suggesting that when the President was talking about reviewing the powers of the Constitutional Court judges, is that consonant with this process?
The reality of the matter is that this government has introduced legislation which is currently before Parliament and which is being debated and engaged with vigorously before Parliament, both by parliamentarians as well as groups, interested parties who are commenting on those legislation, on those pieces of legislation. The issue of the power and the jurisdiction of the Constitutional Court is already before Parliament and it is already being debated. It's not the President who opened that debate. He was simply adding his voice to that debate.
No.
What does this legislation say?
No.
Okay, Sipho
what does this legislation say?
Yeah.
This legislation, in fact, is proposing that the Constitutional Court be recognized as the apex court or the highest court, not only in constitutional matters as is presently the case,
because I think there's
but
a difference
in all
though,
matters.
Minister.
So if anything, government has introduced legislation before Parliament which is widening and increasing the powers of the Constitutional Court, not reducing it.
But the President says review it. The President says look at those powers. Exactly. The President's rationale is that sometimes you have minority judgments that make more sense than the majority decisions.
Exactly. Kolani, may I come in?
Yes, please come in. Let me welcome you, by the way. Thank you very much, Sipho Pityana, for coming in. I'm going to go to the Professor, Stephen Friedman, in a minute. But Sipho Pityana, your views.
Yes, the Deputy Minister and the Minister yesterday in his statement was quite clear about government's position in respect of the rule of law, the respect for the Constitution, separation of powers and all of that. And one expected nothing different. And we welcome that affirmation of those constitutional values. However, it is disingenuous to suggest that the bill that was before Parliament last year that sought to look at possibility of having the Constitutional Court as an apex court is in line with the points that the President was making in respect of the review of the Constitutional Court. These are two separate statements. That debate was aired last year. Of course, there are a number of concerns raised about what that means for the Constitutional Court, capacity issues, competency of incumbents, etc., in respect of having an apex court that looks at issues beyond matters of the Constitution. It's a far-reaching proposal. It doesn't question the current responsibilities of the Constitutional Court. The President's statements emanate from dissatisfaction with some of the decisions of the court, of the Constitutional Court, and proceeds to suggest that the powers of the Constitutional Court must be reviewed. Its precursor is statements that the President made last year about the relationship between the powers of the Constitutional Court in relation to the executive and the legislature. So it's a theme that has been canvassed by the President last year. Now, check this. Last week, the Chief Whip says we have a problem in this country of a one-party state, and that party is the courts. Now, that's really reckless statement that don't sit comfortably with clear and well thought out statement that was made by the Minister of Justice yesterday.
Okay.
So, on the one hand, you have a leader of ANC in Parliament of no less a standing than the Chief Whip making such a statement, and then a few days later you have the Minister of Justice making a statement that is recognized.
So the implication here is that the statement yesterday does not address some of the long-running concerns that have emanated from some of the statements made by senior ANC leaders. Is that what you're saying, Sipho Pityana?
That's exactly what I'm saying. What I'm saying also is that what we need to be looking at is what is this review seeking to do? And that can only come out when the terms of reference are released. It raises the question as to whether the executive itself as executive or through an appointment of an agency through a research institution has, in terms of the Constitution, the right to review the authority, the powers of the Constitutional Court.
All right. Let me bring in Professor Friedman. He's been listening to both my other guests. Professor Friedman, yesterday I heard you on PM Live, and I thought that what you were saying essentially was that, yes, people may have concerns about this document, but they mustn't shut down the door to discussions. Let's debate it.
Absolutely, Golani. And I think already the debate is getting terribly confused, quite frankly. Because, look, the issue is this. Have there been statements by politicians which suggest that there is concern about the courts? Yes, there have. Should we be worried about those statements? Yes, because they indicate that we have a potential problem in this country. If politicians are saying that they don't have confidence in the courts, that clearly is a problem. Where this gets confused is then some people say, oh, well, this is a dreadfully damaging document because it means that the government has some sort of plan to close down the courts. Well, all the document is saying is that there ought to be research and there ought to be a debate. Now, surely, if we have a situation in which there is the kind of problem which Mr. Pityana is concerned about, then the sensible thing to do about the problem is to debate it and look at the research and have a serious conversation as South Africans. That's what the document is asking for, is precisely what we need in this country. And it seems to me to be illogical to say, well, on the one hand, we have a problem because politicians are making these noises. On the other hand, let's not have the conversation, let's not have the debate. Clearly, the fact that politicians are making noises, Mr. Mantashe, the President himself, is precisely why we need this debate, and that's why I think this document is an important step forward. But there is a problem. Those who say it's not broke, don't fix it, are clearly living in a fantasy world. There's a major problem here, and we need to discuss that problem.
The reality is that in every constitutional democracy throughout the world, even those societies that have had decades or centuries of constitutional democracy, still engage in robust and vigorous debate around the respective powers of the three arms of the state. You go to the United States, you will find extremely robust, you will find people in the executive and the legislature decrying judgments of the Supreme Court and saying, no, the Supreme Court has now stopped being a court, it's now making laws, and we don't like that.
The point is that...
But they still respect the court and they execute its judgment, and that is what's fundamental.
But
you can't say, because you're raising issues. You know, yesterday, as we were going to that media briefing, there was a widespread coverage given to a survey by TNS that indicated that up to almost 40% of South Africans didn't feel they even didn't even know enough about our courts to pronounce on whether they felt that they were biased or not. Now, I think that is a clear indication that we need not less but more discussion, debate on our courts and the
but I think, Deputy Minister, the question is, does this document attend to those things? Because this discussion may continue to be elitist. It doesn't necessarily mean that because there's this discussion, then the 40% of the people or the 60% will be involved in this discussion.
No, but what we're saying is that we need to encourage that debate and discussion, and that society as a whole needs to take ownership of that debate.
Kolani, the point is that the suggestion that there should be a debate is a rhetorical one. The debate is on. Positions are being canvassed, and we are objecting to certain assertions that are being made. We're not suggesting, nobody's suggesting that it shouldn't be a debate. The debate is on. This document that was released by the minister yesterday adds to the debate. It doesn't start the debate. What is unacceptable is a suggestion that there must be a review of the powers of the Constitutional Court by the executive because you're unhappy with the decisions of the court. That we're objecting to.
But in a democracy, Mr. Pityana, in a democracy, are we not allowed to raise any issue?
But can I just come in there?
No, but Colin, can I finish? Because
please go ahead.
The deputy minister had the time to finish his point.
Okay.
The court, from time to time, all courts take decisions that we would be unhappy with. And I think Stephen Friedman made a point in his article recently about that judges from time to time would reflect the positions from which they come.
Yeah.
The makeup of the judicial system enables one, when you're unhappy with a judge, to take that judge on through the processes of the Judicial Services Commission. If you're unhappy with the decision of the court, you can take it up through the processes of the court. There can be court decisions provoke and prompt wide public debate, and that must be encouraged.
But
is that a sufficient basis to call for a complete overhaul and review of the powers of the Constitutional Court?
No, but Mr. Pityana, if we are genuine, okay, I'm going to come to you, Deputy Minister. Deputy Minister, I'm going to come to you. Let me ask this question, though, of Mr. Pityana. If we are genuine about the discussion, should we then have holy cows? Should we not say, if it is an open discussion, let's discuss anything and everything that pertains to the judiciary, whether it's the powers of the Chief Justice or the powers of the Constitutional Court?
No, I mean, part of democracy is to open a debate and discussion on all issues.
Yeah.
The issue is that what prompts the debate? You shouldn't create a smoke screen and suggest that there's a broad issues about the judiciary not being anti-transformation, being counter-revolutionary, etc., and that's why we have to have it. The fact of the matter is that the thrust of the reason why this debate is being prompted is that government is unhappy with certain specific decisions that are not highlighted, by the way, in the press statement that was made by the Minister of Justice yesterday. So the only basis on which we're going to have an intelligent conversation about what is being done here is when we have the terms of reference.
Okay.
We'll be clear as to what it is that is being done and what are the parameters of the debate, what the outcome of the debate would mean for policy.
Let's take the professor.
Can I just come in? Because
Deputy Minister, I'm going to give you a chance just now.
But I think there's just one thing that I really do want to clarify, because I think that the discussion is taking place on false premises.
Yeah.
See, Dr. Pityana is saying that we are engaging in a review of Constitutional Court judgments because we are unhappy with those. I mean, that is clearly not what the document is saying. The document is saying, not talking about a review, because a review has a very specific meaning. It means you are looking at something with an intent to change it. Clearly, we are not empowered to change judgments of our courts. What we are saying is that we want to evaluate the impact of Constitutional Court judgments, including, and very importantly, including evaluating, and it says so specifically in the document, including evaluating the capacity of organs of state to give effect to those judgments. All right, but let's
talk a little bit about that, because the problem is, and I quoted something here from the document. It says the President's comments relating to the review of the powers of the Constitutional Court is consonant, and this is the Justice Minister saying yesterday, is consonant with the rationalization project mandated by the Constitution. Deputy Minister.
But I think those are two quite distinct areas. I mean, the area of the document that refers to that is quite a different section that deals with
but it's part of the document.
Of course it is. But what I'm just saying is we are not proposing to review judgments of the court.
Let me get the professor, a very quick word from the professor before I go for the headlines.
People must really read the document, okay? It's not a perfect document. I have criticisms of the document. The document is not saying we have a bunch of fascist judges who are overriding the will of the people and let's take them out.
Yeah.
I think this document is an attempt to diffuse the issue. It is an attempt to address some of the concerns that Dr. Pityana is raising. I read this document very carefully. As I say, I have criticisms of it, but I really did not read this document as saying, look, we have a crisis here because the judges are frustrating the will of the people and we need to sort it out. On the contrary, I read the document to be saying, let's calm down, let's look at some research, let's have a rational discussion. And I think that needs to be welcome. When people say, let's
with due respect, I didn't say that, though. I didn't say that's what the document said.
And let's debate the document.